Hello, my name is Brant Hunt. Today is the 14th day, March, that is 2023. And I'm going to read the last chapter here, Woe Unto You Lawyers, chapter 11, with the author being from Yale University, a professor, and who is rather very straightforward in what he's trying to share with everybody. And he's this particular chapter is going to be upon the law. I think he's basically going to summation of that with Fred Rodell sharing his information. Um, Thank you for being here. I hope that you have eyes to see and ears to hear what he's trying to share with you today. So thank you. So let's get into the book. It's simply called Let's Lay Down the Law. There's a quote here. The first thing we do, let's kill all the lawyers. This is a quote from William Shakespeare. That's pretty amazing where he found that. I would have never thought of that one. But anyway, it's good that he shares that information. From Fred Rodell, chapter 11. Let's lay down the law. What is ever to be done about it? What is ever to be done about the fact that our business, our government, even our private lives are supervised and run according to a scheme of contradictory and nonsensical principles built of inherited meaningless abstractions? What is to be done about the fact that we are all slaves to the hocus pocus of the law and to those who practice the hocus pocus, that is, the lawyers? There is only one answer. The answer is to get rid of the lawyers and throw the law with a capital L out of our system of laws. It is to do away entirely with both the magicians and their magic and run our civilization according to practical and comprehensive rules, dedicated to non legal justice, to common or garden fairness that the ordinary man can understand in the regulations of human affairs. I have also wanted to say this before I forget. I have shared a book that was by Dave Dodge about the missing 13th Amendment. This would educate you in finding out simply is they were not supposed to be practicing law. And that was passed in the mid 1800s, and it was passed by three-quarters of the state, so it was legitimate. And it was actually in pieces of paper that Dave Dodge had actually found in library areas of older libraries, but not only that, simply older book. And yes, it was passed, folks. It was the original 13th Amendment. You've been lied to again. And I would suggest that you look into that. It's not even going to be under my live section on YouTube. It will be in my past videos that I've done probably 3 or 4 years ago. So look for that. Uh, Again, that's important for you to know how you've been lied to again about this issues. Let's get back into the book here. It's not as easy nor a quick solution. It would take time and foresight and planning. But neither can it have been easy to get rid of the medicine man in tribal days, nor to break the straight hold or stranglehold of the priests in the Middle Ages, nor to overthrow feudalism when feudalism was the universal form of government. It's never easy to tear down a widely and deeply accepted set of superstitions about the management of men's affairs. But it is always worth trying and giving enough effort that is support, the effort will always succeed. You can fool some of the people all the time, etc. The difficulty lies only in convincing enough people that they are being fooled. Nor is this, in any sense, a plead for anarchy. It will not be necessary to do away with constitutions or statutes or with the orderly settlements of disputes and problems in order to do away with the lawyers and their law. It would only be necessary to do away with the present matter of phrasing and later interpreting written laws, and with the present manner of settling disputes and solving problems. It would only be necessary to do away with all of the legal language and all the legal principles which confuse instead of clarifying the real issue that arises between men. This is not a plea for anarchy, it's rather a plea for common sense. Interesting, he uses the word, this is a former law professor, folks. They're not clarifying the law. They're mixing it up. And when they're mixing it up, they're not being clear. They're not practicing law. They're practicing legalese, you see. And the first step towards common sense is the realization that certainly and consistently, or any close approximation to them, is utterly impossible in the supervision of man's affairs. It is in refusal to recognize or accept this fact that the law makes it gravest and most basic error. It preems itself as being both certain and consistent. It purports to have a sure answer ready for application to any factual problem or squabble that may arise. Yet even a curious example, that is examination, is enough to show that the law alleged certainty and consistency lies entirely in the never land of abstract principles and precepts. The law has been forced to retreat from the world of facts into its own world of fancy in order to maintain the pose that it is precise and solid science. Moreover, it is a feigning certainty and consistently in the settlement of flesh and blood problems while striving desperately to keep up the illusion in the irrelevant realm of legal abstraction. That the law has lost touch with justice unadored. As mentioned before, justice can't be cut up into convenient categories in the law. In reaching for certainty with one hand and justice with the other, has fallen between the two into a morass of meaningless and useless language, as though any actual dispute could be settled either certainly or justly by reference to the words consideration is essential to a valid contract, or to the words no state may constitutionally tax property outside its jurisdiction. You see, since certainly and consistently are impossible of attainment in the orderly control of men's affairs, the sensible thing to do would seem to be to go straight after justice in the settlement of any specific question that comes up for solution. Now, justice itself is considered an amorphous and uncertain idea. One's man's justice is another man's poison, but that is where written laws came in for. Whatever, that is, wherever different people, different ideas about what is fair and what is right clash head on, that is, written laws and enacted by democratic processes should contain, insofar as possible, the answer. Wherever written laws cannot or do not contain the answer, somebody has to make a decision. And that decision might better be made on grounds of plain, unvarnished justice, fairness, humanitarianism, amorphous though it be than can any other. Today, it is the lawyer-judges who make such decisions, even when some part is taken by a jury, the last and waning vestige of recognition that the ordinary man ideas about justice are worth something. The jury has to act within the rigid framework of the law and the judge's order. Now, you know that most now court cases are not even, there are very few juries anymore. They've eliminated that. But the ordinary man knows as much about justice as does the ordinary judge. As a matter of fact, he usually knows more, because his ideas and ideals about human conduct are more simple and direct. They're not all cluttered up with a lot of ambiguous and unearthly principles, nor impeded by the habit of expressing them in foreign language. A training in the law cannot make any man a better judge or justice, and is all too likely to make him a worse one. But there is one kind of training, one kind of knowledge that can fit a man to handle more ably and more fairly the solution of specific human problems. In any common sense system, you see, that kind of training, that kind of knowledge, instead of adeptness in the abstract abracadabra of the law, would be prerequisite to the right to sit in judgment on other men's affairs. The kind of knowledge that could be readily or could be really useful that would really equip a man for the job of solving specific problems fairly. is technical factual knowledge about the activities out of which the problems arise. Not that such a knowledge would impart a keener sense of justice, rather than such knowledge would enable him to understand the problems themselves more clearly, more intimately, and more thoroughly, and therefore to apply his sense of justice to their solution in a more intelligent and more practical way. A mining engineer could handle a dispute centered around the value of a coal mine much more intelligently and therefore more fairly than any judge that is untrained in engineering can handle it. A doctor can handle the dispute involving a physical injury much more intelligently and therefore more fairly than any judge untrained in medicine can handle it. A retail merchant could handle a business dispute between two other retail merchants much more intelligently and therefore more fairly than any judge can handle it. A man trained in tax administration can handle the Senior versus Brayton much more intelligently and therefore more fairly than the Supreme Court handled it. In short, even discounting for the moment the encumbrance of legal doctrine that obstruct the straight thinking process of every judge, the average judge is sadly unequipped to deal intellectually with most of the problems that come before him. And why, after all, should not the orderly solution of our business and government and private difficulties, that is, practical problems, all be entrusted to men who have been trained to understand the practical problems and to appreciate the difficulties? Why should we continue to submit our disputes and our affairs to men who have been trained only in the ethereal concepts and abstract logic, and who persist in pursuing that will of the wisps certainty? Why would we keep on sacrificing both justice and common sense on the altar of legal principles? Why not get rid of the lawyers and their law? It would take, of course, a peaceful revolution in the system of rules under which we live. Constitutions, in part at least, would have to be rewritten without benefit of lawyers. Why not? Machinery exists for the machinery exists for a long time in its orderly and peaceful way. Where constitutional commands and prohibitions make sense to the average man, they can be kept unchanged. Anyone understands, for instance, what the federal constitutional requirements of a census every 10 years means. Where constitutional commands and prohibitions are completely incomprehensible except in the light of legal interpretation. They should be clarified so that they do not make sense or else omitted entirely. Why should the lawyers have a monopoly on the understanding of any part of any constitution? Statutes would all have to be redrafted to, again, without benefit of lawyers. And that would be a tougher job, but by no means an insuperable one. The lawyers themselves have often done it with a whole body of written laws. They call it codifying the law. There is no reason why a chosen group of non-lawyers should not codify the present laws of every state and of the federal government as well, and codify them so that it no longer takes a lawyer to translate them into significance. Any law that means something definite and tangible in relation to human affairs can be written so that its meaning is plain for all to read. Any law that means nothing except as lawyer and lawyer-judges put content into the inherited contentless language has no business staying on the books. Furthermore, any law which instead of laying down rules itself turns over the solution of certain factual types of problems to a group of experts or administrators should say perfectly frankly what is doing and should define as factual instead of legal language, the field within which the experts are to make rules and decisions. Why conceal behind vague generalities the fact that the Securities and Exchange Commission has been given within vague limits the power to make rules for the running of the New York Stock Exchange? Why not make the granting of power simple and direct? And why not make the limits of the power specifically instead of leaving their determination to a lawyer judge? Correct. Subsequently and haphazardly interpretation of the status of the statute legal language. Yeah, just say what it means. That's all you got to do. But what they've done is they've used a little of this fairy dust type of thing and make it look like it's something else. It's like a little mystery, Similarly, any written law which though laying down a broad rule leaves to a court or some other deciding body the precise application of the rule to the fact of any particular problem should say that it is doing just that. First-degree murder is punishable by death. It makes no real sense as a statute because first-degree murder makes no sense except in relation to the abstract legal principles which are said to define it. When a court, that is in brackets here, whether judge or jury or both or some other kind of deciding body, finds that one person has killed another person and believes that the killer deserves to be electrocuted, the court may order that he be electrocuted. It is equally as descriptive of the rule and much more accurate. Why not phrase the statute that way so everyone would know just what it did mean? Then we should want the rule to be more precise. The written law could be made more precise. Instead of pretending that the words first-degree murder contribute towards preciseness or towards anything but obscurantism and unintelligibility. For a course, there would still have to be courts, you see. There would have to be judges or decision makers under any orderly system of social control. Even though written laws were made intelligible to all, there would have to be decision makers to determine the true facts behind any dispute, and then to apply to the dispute the terms of any written laws, whether these laws were so precise that their application was almost automatic, or whether they left room for decision makers to exercise their own discretion and their own own sense of justice. There would have to be decision makers too to settle any dispute which were not covered by written laws. And as it is written, decision makers that men trained in technicalities of factual problems rather than in the technicalities of legal language would come in. You see, suppose today a problem in the regulation of utility rates comes before a court of law. The company will argue that its property is worth a great deal of money because the more money it's worth, the more money it is worth, the higher rates it can charge, since it is allowed to make a fair return to the reasonable value of its investment. The Utility Commission, out to defend the rates it ordered the company to charge, will argue that the company's property is worth considerably less than the company's figures. Both the company and the commission will bring in engineers and accountants to testify about the value of the company's property. The company's experts will set a high figure, and the commission experts will set a low figure. And the court, unable to understand or gauge intelligently the basis of either set of figures, will more than likely split the difference and let it go at that. But why? If the commission, which is a government body just like any court, is not to have the last word in applying a written law entrusted to it for enforcement. Should not the dispute at least be brought before a court of engineers or accountants, or both, who, unpaid by either side, could apply their technical knowledge to examination of both sets of claims and intelligent choice between them? Suppose today a man accused of a crime pleads before a court of law that he is insane and therefore cannot be held responsible. The prosecuting attorney will produce psychologists who insist and explain in medical terms why they insist that the defendant is sane. I don't know if I agree with that idea, because I wonder the psychologists and psychiatrists are quite mixed up themselves these days. The defendant attorneys will produce psychologists who insist and explain in medical terms why they insist, and the defendant is crazy. The court will listen comprehensively to both sets of psychiatrists and will then go into a huddle with itself over the question whether the accused man or understand the difference between right and wrong. If he can, he is sane according to the law. And if he can't, he is sane according to the law, no matter how ridiculous the basic or distinction may seem and does seem to any psychiatrist. But why should the dispute be brought immediately before a court of psychiatrists, or before a single psychiatrist, that is, a judge, who, unpaid by either side, can apply technical knowledge to examination of the defendant's claim and make an intelligent decision as to its validity? Suppose today a complicated dispute over the internal management of a corporation comes before a court of law for solution. Lawyers for both sides will defend their client's action and interests in elegant legal language. The court, in making its decisions, will choose between two profited sets of legal principles. Why legal language and legal principles? Why not consideration of business efficiency and business ethics? Why should not the dispute be brought before a court of men experienced in corporate management who could apply their technical knowledge to an examination of the claims of both sides and to an intelligent, practical, as well as fair solution to the difficulty? It is no answer to say that a lawyer, judge, understands better than does an engineer or accountant or a psychiatrist or a business executive the other issues involved in these cases, or any other, or 1,000 types of cases that might be named. The only real issue ever involved in any case is the intelligent formation of a fair decision to a factual problem, either within the framework of some reference, that is, relevant written law, or, if necessary, without reference to any written law. The only understanding helpful information formulating such a decision. Granted that the words of any relevant statute make sense, and if they don't, they should be ignored. It's practical understanding of the problem involved. An engineer or an accountant or a psychiatrist or a business executive, remember, has just a keen and impartial a sense of justice where his own interests are not concerned, as has any judge where his interests are not concerned. Moreover, if two or more kinds of specialized knowledge are pertinent to the settlement of any problem, why should not two or more kinds of technical experts compose the court which settles the problem? Why, in any case, should the real issues ever be obscured by the fake issues of the law? In any common sense system of social control or government, the courts, the law applying and decision-making bodies would be built on men trained to understanding of the different fields of human activity with which they were to deal. The exact mechanics of such a scheme could be worked out in any one of several ways. Perhaps permanently courts of experts in different fields of practical knowledge might be set up, each to handle all disputes and problems that center around their own fields. Perhaps instead of taking men permanently away from the work to which they have been trained and making specialized judges out of them, there might be a panel or experts on call for a part-time court service in the settlement of disputes involving their separate fields of knowledge. Perhaps for any such scheme would have to include a central directing bureau to arrange for the hearing of each case before the right court. There might be central courts composed of a dozen different kinds of specialists. You see, an ex-business executive doctor, as an ex-doctor, and an ex-labor leader, and an ex-engineer, and an ex-banker, and an ex-farmer, and an ex-public administrator, and so forth. And each central court might assign the handling of every case that came along among its own members or among other specialists it is available for services, or among a relevant combination of the two. Perhaps each field of dispute might have its own central court and its own outside part-time judge. Thus, a central criminal court might include an ex-penologist and an ex-financial expert and an ex-doctor and an ex-police officer and a couple more with a chemist and a psychiatrist and a ballistic expert, among others, on call to sit in certain cases where their special knowledge would be of help. Even the Supreme Court, composed of course of non-lawyers, and this incidentally would not even require an amendment to the Constitution which says not a word about the judges having to be lawyers, might well make use of outside specialists as part-time judges. And since most of the problems that come before the Supreme Court involve and would probably continue to involve practical problems in government, most of its members, as well as the members of any other courts devoted to handling such problems, would be men trained and qualified in the efficiency and wise administration of government affairs. As a matter of fact, abolition of the lawyers and their law might eventually lead to the virtual disappearance of courts as we know them today. Every written law, you remember, in comprehensive language, might be entrusted to a body of technical experts to administrate and apply it and make specific decisions under it, as the Interstate Commerce Commission applied the Interstate Commerce Act, as the Federal Trade Commission applies the Clayton Act. Or so each state would have, say, a killing commission to apply its laws about what are now called murder and manslaughter. Moreover, the decision of the technical experts who make up each commission would be final. There would be no appeals and no super appeals to other bodies of men who knew and understood less about the real matter in dispute than the original deciders. There would be a Supreme Court or a Supreme Commission or such to settle important intergovernmental or intragovernmental squabbles to which the written laws did not contain the ready answer. But just about all that would be left for courts, or something like our present courts, to handle would be disputes to which no written laws directly apply. And where no written laws directly apply, arbitration of the dispute by picked specialists in that field or that business would serve the ends of efficiency, justice, and also economy far better than a formal trial before any kind of court. If even the remote idea of eventual disappearance of our courts has a shocking sound, it is only because of our blind faith that the mysterious processes of the law do somehow work inexorably towards certain justice. Well, for the 10th time, they don't. When the courts happen to produce justice, it is likely to be despite the irrelevant process of the law is because of them. Nor for all the legal legend are judges infallible arbiters of right and wrong, fair and unfair. Judges are men, not gods. Moreover, they are government servants, government employees. Why should not another group of men, another group of government employees be equally able to decide what is fair and what is unfair? Why should not another group of men given equal opportunity or responsibility and trained to understanding of complicated practical problems be better able to decide what is fair and what is unfair within the limits of an intelligible statute than those who have been trained mainly in the manipulation of abstract principles? Why should not a commissioner word be as good as a judge's word? Thus, or shall I say true, the mechanics of any such system as has been suggested to replace the lawyer-judge would be complicated in the extreme, but no more complicated than the present confusing, overlapping, and wasteful hierarchy of trial courts and appellate courts, state courts and federal courts, courts of law and courts of equity, police courts and magistrate courts, common plea courts and special claims court, and all the rest of all of them manned by exalted lawyers. And if the whole idea of taking the settlement of our disputes and problems in one fashion or another out of the hands of the lawyer-judges sounds too fantastic, too far-fetched, and unfeasible, a couple of little points are worth considering, for small steps in that direction have already been made in the field of government and also in the field of business. In the field of government, the growth of commissions and boards and all sorts of administration bodies have served to deprive the courts of law of some of the decision-making business that used to be theirs. Today, most new statutes are put into charge of special decision-making agencies instead of being entrusted directly to the court for interpretation and application. It is true that today an appeal to courts can always be taken from any commission's decision, but the commission really stands in the place of a trial court, you see, and appeals are comparatively few. It is true, too, that these commissions are now usually manned in large parts by lawyers, but even the lawyers' commissions are coming more and more to be chosen for their familiarity with the practical problems with which the commission has to deal, rather than for their adeptness at the law. At the least, it is a trend. In the field of business, the first halting steps, that is, away from the lawyer-judge, has been the growth of arbitration as a means of settling disputes. Arbitration means nothing more than the voluntary turning over of a dispute for fair settlement to a man or group of men, trusted by both sides and equipped by specialized knowledge to understand the question at issue. Lawyers are not necessary, either as arbitrators or as advisors, and experience has proven that their presence is all too likely to hold up and confuse the whole proceedings. They just can't forget their abstract principles, nor their pleading and procedure ideas, and get down to business. Most judges, incidentally, disapprove heartily of arbitration and say so whenever they get a chance in a law school, as when a contract provides for it. They well know in what direct arbitration as a system is heading. As a matter of fact, to go back for a few minutes, that is, to the possible mechanics of setting up substitutes for the present court of law, one scheme might be the tremendous extension of the arbitration device. Thus, the two sides of what the court would call a civil suit, an ordinary case not involving the government, might be required to pick their own expert or experts to settle their dispute for them, perhaps from among a qualified list of arbitrators in that field, or perhaps not. Certainly, such a requirement would fit in perfectly with the complete abolition of courts as we know them, with the use of commissions or such to decide matters arising under written law. For All disputes not covered by written laws could then be turned over to arbitration. At any rate, regardless of the exact details or mechanics, the important thing in any common sense system would be to get rid of the abracadabra of the law as alleged basics for the settlement of human and social problems. That would mean cleaning all the vague and essential meaningless legal language out of constitutions and statutes. It would mean taking the settlements of specific disputes out of the hands of the lawyers as judges. And finally, perhaps first of all, it would mean getting rid of the lawyers as lawyers. Getting rid of the lawyers would mean no more legal counsel to talk for you before the courts or commission or arbiters or whatever bodies were given the job of banding, I should say, of handling specific problems in the orderly management of human affairs. People who got involved in disputes or got hauled up for alleged violation of some written law would have to tell their own stories and produce their own proof in the form of written evidence or witnesses or whatever kind of proof was necessary and available. Companies would have to send to court a responsible company official to talk facts and not law. Why not? Since the decision makers would no longer be concerned with balancing abstract principles, but only with applying justice straight to the problem before them. Not that is, despite what the lawyers will immediately howl, would it be one whit harder to determine the true facts behind any dispute without the help of the lawyers and their principles of P&P. And everybody knows at least one of the lawyers in every case in which the facts are in dispute is out to hide or distort the truth or part of the truth, not to help the court discover it. And his is always able to use deceptive principles to help him to do it. The notion that a clash between two trained principle wielders, one of whom is wearing the colors of inaccuracy and the falsehood, the truth will always or unusually prevail, in essence nothing but a hangover from the medieval custom of trial by battle, and its essence equally absurd. Why not let the people really involved in these squabbles tell and try to prove to the satisfaction of the decision makers their own lies? Commissioners have often found it far easier to discover the true facts behind any dispute by dispensing with the lawyers. The rules, the arbitrators have found it easier still by dispensing with the lawyers. Getting rid of the lawyers altogether would also mean no more legal advice for those who can now afford it. In the making of financial arrangements and the drafting of business documents, people and companies who make financial plans and business agreements would have to word them or have them worded by non-legal draftsmen in intelligible language. Why not? Why should not a man who wants to leave his property to his wife as his death say in his will, I want everything I own to go to my wife when I die? That's all you got to say, you see, instead of having to hire a lawyer and go through a long rigmarole of legal language. It benefits them, folks, you see. It benefits them. They've created their own system that benefits them, not you. If the written law about wills says, for instance, that 3 other people have to sign a person's will to help prove later that he signed it, then let the written law be not only intelligible, but as readily available as a guidebook of an article in an encyclopedia. And why should not 2 people or 2 companies or a company and a person who want to enter into a business agreement be both entitled and required to state in plain words just what each of them is promising to do or not to do? And constitutions and statutes were all written in ordinary English, and if the lawyer-judges were ousted from their decision-making seats, the practicing lawyers would soon automatically disappear. There would be no more use and no more place for their magic. The practical man or practical men in charge of dispensing justice would neither understand nor be interested in the abstract principles of the law. Legal language thrown out of the new courtrooms or commissions chambers would serve no possible function in the wording of business documents. Neither as advisors out of court nor as representative in courts would the lawyers be able to sell their special brand of verbal skill. Then, too, the law schools would be forced to close their doors or else to turn themselves into schools of practical government or business administration. The breeding of word jugglers would come to an end. Yes, it might be just as well to get rid of the lawyers directly, along with the lawyers, judges, and the legal wording of written laws. And at least they would have to be voted out of Congress and the state legislature before it would be possible to redraft constitutions and statutes and set up a new decision-making system. And if the lawyers as lawyers were abolished directly and immediately, then the other changes would go into effect more smoothly. How abolish the lawyers directly? Well, why not make the practice of law for money or for anything else a crime? That's a good point. The lawyers would, of course, insist that anything so unheard of could only be done by amending the Constitution. Why not amend it? And incidentally, only a lawyer would quibble about what the practice of law means. You see, absurd, preposterous. Think it over for a minute. Suppose the nation was suddenly to wake up to the fact that all of its affairs were being supervised and controlled according to the language and principles of astrology by a smart bunch of astrologers. Would making the practice of astrology a crime seem absurd? Go back and read over again the solemn judgment of the Supreme Court of Lawyers in the case of Senior versus Braden, or pick some other court opinion at random and see where the absurdity lies. Or are we just to go quietly, unquestionably, and stupidly on, submitting the management of our entire civilization to the modern medicine men? The immediate answer is undoubtedly yes, but it needs not be a permanent answer. And any popular movement to get rid of the lawyers and their law, and to put our system of social control on a common sense basis, should ever make enough headway for the lawyers to have two-face instead of scoffing at it. Their cheap arguments against it, other than those already considered, would probably boil down to two. They would argue in the first place that even in the time-tested legal system, with all its principles and precepts were scrapped and another sort of system set up in its place, the new system would soon develop its principles and its precepts too, and even its special language. Now, if the new system were put in the hands of lawyers or other men who trained and skilled principally in abstract logic, that would impressively be so. But it would not be so if the new system was entrusted as it would be entrusted to men trained and skilled in coping with practical human problems. And it would particularly not be so if those in charge of the new system were aware, as they would be aware, that there need be no pretense of preordained certainty and consistency about their decisions taken in the mass, but rather a direct effort to deal intellectually and justly with each problem or dispute as it came along. Finally, the lawyers would argue that if the law were scrapped and it became generally known that fallible men rather than infallible and impersonal abstract principles were the dictating decisions which other men had to obey, then all respect for law and order would vanish, and revolution or anarchy or both would ensue. But in this argument, a typical magician argument in the conjuring up of frightful imaginary hobgoblins, and display a strange and contemptuous mistrust of the civilized tendencies of the nation. It implies that the whole structure of our society would automatically go to pieces if it were put on a practical rather than a mystical basis, an unwarranted assumption at best. Moreover, in this argument lies the crux of the whole fraud of the law. For the average man's respect, such as it is, for our present system of law and his consequent willingness to let his life be run in mystical fashion by the lawyers, are indeed founded on the careful, nurtured legend that legal principles are just about as infallible in what they produce in the judge's hand and something very close to certain justice. Which, to sum it up all in 4 words, there aren't and don't, is a blind respect, born not of understanding but of fear. And the fear is built on ignorance. If only the average man could be led to see and know the cold truth about the lawyers and their law, with the ignorance would go the fear. The fear would go to the respect, and indeed, and doubtlessly, in orderly fashion too, it would be woe unto you lawyers. So that's the end of the book today from Mr. Fred Rodell. He has some good deals here, folks. Some good ideas. I see some good ideas here in this last chapter explaining we need to get rid of lawyers, and we do, because they are not seeking justice. They're basically seeking, quote unquote, to pad their wallets. And it's been a long time, folks. And it's become a monkey trials that take place now, and the truth is not getting out. And that's the real problem, you see, because there's only those who, quote unquote, are making money at it. You know, they're making money at selling justice, but in reality, it's not justice, you see, at all. So thank you for being here. I wanted to just again, this is a very vital book for people to understand because this was a professor of a law school at Yale University, and this was in 1939. He was in the time he saw what was coming. He was also aware that Mr. Roosevelt was stacking the court, was going to be stacking the court because he saw it. It was his whole idea because he wanted his ideas to be changed. You see, that is the wrong way to do it, folks. Do you understand that? By choosing a judge and these judges, that is the 9 judges, you make law. That's not what they're supposed to do. And in reality, what's happened simply is he has overstepped his bounds. If you want to change the law, you're going to have to amend it. You see, you're going to have to create amendments in order to change it based upon the Constitution. It's the only way to do it, folks. And you're going to have to get people, what we call these people in office, that basically you need to, as it was passed in the 13th Amendment, the missing 13th Amendment, you got to keep lawyers out of it. Lawyers don't need to be politicians, folks, because if they are, they'll just create the same thing over again and over and over again. That's the key. It's the same thing with what we see today with the bankers. They do the same thing. They destroy and pillage people. We got a messed up system here, folks, everywhere. We not only got problems with the medical field with doctors who are not healing people at all. We also got problem with bankers that create money out of nothing that is actually run by a private group of bankers, which is called the Federal Reserve System. And we have a group of people who are the lawyers who are actually creating laws or making laws as it goes along. And that's wrong. And it's time for people to, again, like I said, have eyes to see and have ears to hear in order to see that our country is in desperate shape. It doesn't take a rocket science to figure that out. And again, this was the 3 things that basically, even when you speak about this, Jesus spoke out against the 3 people. He talked about the money changers, which was the bankers. He spoke out against the lawyers, which is what we're talking about. And he spoke out about the priests, the people who create their synagogues or their churches to make you feel you're an evil person, that you are born a sinner. No man is born a sinner, folks. That's a lie from the pit of hell. So you need to know these things, and you need to understand those, and you need to teach these things to your children. If you want a good society, you must take the responsibility to passing on the knowledge to the young. Because if the young don't get it, there's nowhere, it's going to be far worse in their day than it is in our day. The hour is late, you see. So I just thank you for being here and spending time with me. I hope that you grasp what I'm sharing. These are excellent authors that I'm sharing from you each day, trying to hopefully you to see the truth of the whole thing. So thank you, and you have a good day, and we'll be back on probably later on this evening. Thank you.